This is Michael Cowen, and welcome to Trial Lawyer Nation.
You need to show people the worst possible harm that negligence could have caused, because that's what the case is about.
What I'm asking you to do is to focus on what you can control, because that's where the power lies.
The Dalai Lama has a saying that in the face of anger, justice evaporates.
If you can't focus group it, you have to be very, very critical of your process.
The facts aren't good, you can't create a miracle.
We can agree to disagree and be zealous advocates for our clients.
Quit worrying about looking perfect. You're not going to. That'll come in time, but you can still be an effective litigator.
Welcome to the award-winning podcast Trial Lawyer Nation, your source to win bigger verdicts, get more cases, and manage your law firm. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowen.
Today on Trial Lawyer Nation, I have my partner, Malorie Peacock. How are you doing today, Malorie?
I'm doing good. Hanging in there, just waiting for our election results.
Yeah, we're recording this on November 4th, so we still don't know the final results of the presidential election. But it's time we have no control over that. It's time to get back and focus on our cases. And so in our Trial Lawyer Nation's Insider Circle, one of our members, Travis Johns, had a request. He said, always wanted to hear an in-depth approach of how y'all approach a case from the outset, such as once you've determined you're taking the case, what steps are next? Is there an evaluation process, setting up investigations, preservation letters, etc.? I think that's a great topic. So you ready to talk about that today?
Yeah, I absolutely love this topic because we put so much thought into this over the past few years. And Michael, I think you've actually come up with a pretty succinct method that we might want to talk about today.
Yeah, I have to give you credit because you think you actually came up with the initial outline, but except it got up to I think 20 steps or something like that, and then I kind of took your work and drilled it down to a 9-step method because I'm writing this book that I've been saying I've been writing for 2 years, and one of the things we had to do in writing a book is I know what we've been doing, but I know how to do something, but it's just like, how do I explain to someone else what we've been doing? And it's kind of so taking what we've just kind of, just been learning in bits and pieces over the years and just putting it into one kind of comprehensive set of rules and instructions, I guess. So here's the 9-step method that we've come up with. Now there's going to be stuff within each step. But the first is initial triage, which is, is this a case we even want to look at taking? And then, we gather all available information as the second step. The third is identify and analyze potential immediate causes. And we'll get into immediate root cause also during this discussion. 4 is a root cause analysis. 5 is to draft the jury instruction. 6 is to find roles and anchors. 7 is to formulate our discovery plan, and we try to do all that before we actually file the case. 8 is to continually reevaluate the case once we file it, and then 9 is to test the case before we decide whether to try it or resolve it. So that is that's the plan. I guess the podcast is over now, right?
Well, for those of you who are eagerly awaiting Michael's book, which I'm one of them, this is kind of this is going to be a sneak preview of some of the stuff that's in his book. So I don't know, what do you want to do, Michael? Go through each step, start at the beginning?
I think so. I think the first step, I think, is the most important one. So.
All right. So it's this 9-step process. And for those of you listening, as we go through the podcast, we'll keep step we're on, but a lot of these steps are going to be before you ever even file a lawsuit. So just so that be ready. We're not going to be filing lawsuits until the end of this podcast.
And the steps are going to be in the show notes. So if you're driving, don't try to type them down or anything like that. The steps will be in the show notes. So if you want to look at them, just go online and you can see them. Or sometime in 2021, if I can get this darn book finished, and I'm way behind on that. Trial Guides has been so nice in not firing me. But sometime by the end of 2021, it'll be available. But for those of you that want to actually work on cases before then, check out the show notes and we'll have the list.
All right. So step one, initial triage. What does that mean?
Yeah, triage is a term. It actually comes from battlefield medicine. And it really seemed to be a good analogy for what we do. And so on the battlefield, I mean, it's a horrible place. And so they'll have more wounded people, soldiers coming in than they have doctors and facilities to treat. And so they have to make these horrible decisions. So they're going to have to look at, let's say we have 3 soldiers and we only have the medicines, the beds, the nursing and doctors to really treat one of them. Well, is this one person, although they may suffer, going to get, not going to die if we don't get to them right away? Can that person survive? Is this other person probably going to die no matter what? So we're just not going to put our resources on them, because if we do, there's the person in the middle who needs us right away and can be saved by us. And so they have to decide, some people are just going to have to sit and suffer till we get to them, and some people are going to die, and we're going to have to let them die. And it's horrible. It's a horrible decision those doctors and nurses have to make. But if they don't make those hard decisions, even more people die, because then the people that they spend all their time trying to save the unsavable, and then as a result, they don't save those that can be saved. Or they try all the time giving comfort to those that don't need it, that aren't going to die right away, and then other people die because the people that need the resources right away don't get them. So horrible situation. I'm glad we're never in it, but it's analogous to what we have, because we only have a finite amount of time and resources. And so, we have, like lately we've been blessed. We've had all sorts of cases coming in. So we have to really look at, okay, given the fact that I have a limited amount of time and resources, and I already have other cases I'm working on, is this a case that it makes sense for me to drop what I'm doing and work on it? And it's a hard decision. But if we take everything in, then we can't do anything well. And so we really have to make that initial decision, is this a case I should even be looking at?
I think that case selection is the biggest challenge for a lot of attorneys. I think it's easier said than done for everybody, because one, you feel like, if I don't take this case, will another case come in tomorrow or next week or next month? There's always the case that comes in that you think, I could make something out of this. Right? If I worked on it, I could do something with this. But sometimes you have to turn those down, even if you think that you could make something out of it, because there's something else that needs more of your attention and that you can do more with.
And that is the thing. There are cases that we are turning down that we could do something with. But one is just knowing that there's also someone else out there that could do something with it. We are not the only decent lawyers in the country. There are lots and lots of decent lawyers in the country. So do I want to take time away from my other cases, from my other clients, from my family and my personal life, to work on a particular case? And getting this wrong makes it impossible to do the rest of it, because the method we're talking about takes time. It takes resources. And so, you need to decide what you're going to be. Now, I'm not saying that everybody has to have 4 cases. I mean, we have more than 4 cases each. And there are cases that are better suited for a volume firm. If you have like soft tissue car wreck cases, it does not make sense to have a small docket of soft tissue car wreck cases. Those clients are going to get better justice at a firm that can handle them in volume and do them effectively, because they're going to be able to get the resources and dedication. They're going to get really good at doing what they do, and they're going to handle those cases well. But I don't think you can really handle the big volume of small cases and handle the bigger cases with the time and resources they take. So you kind of have to decide where you are in your career, what you're going to be, and then what you're going to say no to. But if you say yes to everything, you're really saying no to excellence. You're saying no to doing a really good job. And every time you say yes to a new case, you're telling your existing clients, no, I'm not going to spend all my time on your cases.
One of the real challenges that we've had is identifying what cases we should take and what cases we should not take. And we've actually come up with a complicated decision matrix for helping us decide. But the reason for that is, one, then we don't have to be in charge of every single decision about case intake at the firm, because that takes us away from the thing that we should be doing, which is legal work. But then two, it helps us to stick to what we said we were going to do, which is very easy to get away from when you see a case or you see a client that really you feel like really needs your help and you really want to get in, you want to help them. But if we have that written down somewhere that we can refer back to, we can remind each other, remember, this is what we said we were not going to do. So I would suggest to everybody, write down what it is that you want to take and then stick to it and keep yourself on that path.
And what I found is when we've had the courage to stick to it, the universe sends us the right cases that we want. And I'll give an example. I mean, I used to do a lot of automotive product liability cases. I still like them, but they're very time consuming. They're very me intensive, and that, you and I are the only people at the firm that have a lot of experience doing these. So they're not cases that we can, hand off to someone else to do 85-90% of the work at the firm yet. I mean, so we could dedicate the time. We have people that are capable, but it would take a couple years of training and me working with them or you working with them to get them up to speed on automotive product liability. And they're just not as profitable, frankly, as the trucking and commercial cases. And so I've turned down, I think, 5, automotive product liability wrongful death cases this year that, 5 years ago, I would have been doing backflips to have gotten those cases, because they're all cases that someone is going to make money on. They're all, they weren't slam dunk cases, but they're all cases that have settlement value, that have the potential, that are potential trial wins. They're not guaranteed. But they're all decent cases. But I stuck to my guns and said, no, we're not going to be doing these cases anymore unless it's like a really, really special case or something where we already have all the documents. We know exactly how to do it. And then lo and behold, now we're getting a ton of trucking cases in. I mean, just a flood of them, which is wonderful. And now we're having to make the decision even on some of those cases. There's cases that a year ago we would have wanted, but now we're looking at, well, again, we've had a lot coming at once. Are we best suited for this case? Do we have the time and resources to do this particular case, or should we pass on this one to work on the other ones coming in?
It's a complicated decision, and I don't think there's so many different kinds of practice areas and so many ways that you can set up your practice that, we can't give you all the answers for how to accept or reject cases. But I think sticking to what you want to do is the best advice that we can give.
You also have to be realistic where you are in the market at the time. And so, right now we're blessed. I've been doing this for 20 something years. We've built up a reputation, so we can be fairly selective on what we took. If, when my boss quit, when I was 3.5 years out of law school, and, I was trying to get a practice going, if I had tried to be so selective, nobody would have given me any cases. I mean, as a 3-year lawyer, if I said, well, I only want trucking, death, and serious injury cases, they'd like, well, who do you think you are? And at one point, there's some of that. Who do you think you are? Well, if you decide you're an expert and you decide you're good on something, you will be. I mean, look at Joe Freed, for example, out of Atlanta. When I met him, he had never done a trucking case, and I was already doing trucking cases. He did really specific Ford vehicles that caught on fire after they crashed and someone burned cases. And he decided one day he was going to be a trucking lawyer, and he just decided to do it. And those are the cases he was going to do. And he found a way he studied it real hard. He found a way, work with people that were getting trucking cases, market himself as a trucking lawyer. Now, of course, Joe actually did become probably the best trucking lawyer in the country. So, I mean, on one hand, he just didn't bullshit his way and say, well, I am because I say I am, even though he wasn't. He did the work and became a really, really good trucking lawyer. But he made the decision to be one before he was one. And, I think anyone can say, I have passion for this. I'm good at this. This is what I'm going to do. And just tell everyone that's what you do. And it will come, believe it or not.
So after you decide you're going to take the case, so let's say that you've gone through your own matrix and you've decided this is a case that I think I can work on. What's step 2? Okay,
well, let's take a step back. We're not deciding we're going to take the case yet. We're deciding we're not going to say no, we're not even going to look at the case. So step 1 is this a case I even want to look at? And it's really important. And you and I have actually had this discussion on a case that, we're probably not going to take after putting time and effort in. So step 1 is triage. Do I even want to look at this case? And I want to go back onto one other thing on triage too, is I used to be so scared because most of my cases come from referral that if I said no to a referring lawyer, that the referring lawyer is going to go somewhere else and I was never going to get that referring lawyer back. What I'm now doing, and it was a step of faith and a step of courage, is let's say these automotive product cases come in. And so I'm saying, no, but let me set you up with someone who's really good. And I'm introducing my lawyers, my referring lawyers, to lawyers that actually compete with me. They do trucking cases too. But to other lawyers that are really, really good at the automotive product stuff that do that. They do it, it's a regular part of their practice, so they have an economy of scale. They have an expert come in and look at 10 cars and not just one, which makes it a lot more affordable to do. And I just have to have the faith that I'm not going to lose these people's trucking business because I sent them to the other lawyer. Now, I do have a conversation with the other lawyer. Hey, dude, I'm going to get you some product cases. If I find out that you're hitting up these people for trucking cases, I'm not going to send you anymore. But I mean, that's just purely on faith. I don't know what conversations they're having, and I also don't know. I mean, even without that person asking, that person really, really impressed them, that we might lose the referral source, but it hasn't happened. When I've had the faith of, look, let me be the person you come to. Whatever case you have that might be a good case, come to me. And if I'm the right lawyer for it, I'll help you on the case. If I'm not, I will honestly tell you someone else is better for this case than I would be for this case. And so let me introduce you to that person. And then I'm still the trusted source. They still come to me. And I haven't lost anything since we started doing that. So like I said, it was a leap of faith. I was scared to do it for years. But now that I'm doing it, it really seems to be working out better. So I just wanted to mention that. So but again, the initial triage is just, do we say no right away? It's not, do we say yes? And that's another really important thing, because so many times in my career, I've taken in a case and we've done our initial investigation. We've hired experts. We spent some money, and then it's clear the case sucks. But because I put money into it, I want to get that money back. And so I keep working on the case to try to get a settlement to get the money back that I already spent. And then I spend even more time, effort, and money in it. And then I end up getting a settlement where I cut my fees down to almost nothing to get my expenses back. And, it's called the sunk cost fallacy. That, if once you put time and money into something, you make economically irrational decisions that if you just write off what you already spent and spend your time on something profitable, at the end of the year, you will make more money. You will have better success. But it's just so hard for us to say, well, I've already put time and money into this. I got to do something with it. Like, no, the initial triage is, do I say no right away? It does not mean we're saying yes.
So then what do we do to determine if we're going to say yes?
Yeah, so the next step is to gather all the available information. So, like I said, the initial triage is only based on the very limited amount that we have at the beginning. It's usually like a conversation, a police report, something else. And so, what information is available is going to depend on how early you get hired. So let's take a truck crash case, for example. First of all, if the vehicles are available, you want to get someone to look at the vehicles. If the damages support hiring an expert to look at the vehicles. You want to get someone to look at the scene. Of course, you want to get the police report. You want to talk to any witnesses who were there. You want to photograph everything. You want to go ahead and go online and see what information you can get from the Federal Motor Carrier Safety Administration website about the trucking company and their safety history. We go ahead, and part of our process is we send out a Freedom of Information Act request, within a day or two of a case making it past triage, because it's taking 6 to 9 months for the government to respond. And we want to get in our place in line as soon as possible. So we get that out. We don't wait to make a decision based on that, but we get that out. We send out preservation of evidence, or what they're called spoliation letters, to the defendant, to the driver, to anyone else that might have evidence, to try to keep evidence from going away. We talk to our clients. We might gather some initial medical records. I guess that's basically what we do on that kind of case.
Yeah. And every case is a little bit different. It just depends on the kind of case and what's available. If you're doing a premises case, what information is available is going to be different at the outset. And the same with a workplace injury case. Yeah. The information that you're going to gather is a little bit different. But what you want to do is think about all of the sources of information that you can get quickly, and that can help sort of form your ultimate decision about whether you're going to jump into the case or not.
Absolutely. And, I think the big thing is we get all that information and then we have to look at it again. And then I think we have to take a step back again and say, okay, now that I have as much of this information as I can reasonably gather at the beginning of the case. So we don't wait the 9 months for the information to come back from the Federal Motor Carrier Safety Administration, for example, because that's usually icing on the cake type stuff. But okay, now that we have a general idea of kind of sort of what the liability stories are going to be, what the big issues are. We haven't deposed everybody, but we've got an idea of kind of how much of a fight is liability going to be? What's the property damage on the vehicle look like? And kind of what kind of injuries are we looking like we're going to have? Is this something where someone was clearly, they're in the hospital right away with broken bones or severe traumatic brain injury? Or are they getting better really quickly? Or is it something where they're in pain and this may be a case where when they do an MRI, they're going to end up with back surgery, or it may be a case where they're going to get better in 6 weeks. We don't know yet. And it could go either way. So we get all that information and then we have to ask ourselves again, okay, yes, it made it past triage, but knowing what I know today, is this a case I should take? And don't be afraid, because we feel like, okay, we've already worked on the case. Well, now we have some moral or social obligation to the client or the referring lawyer to keep working on it. We don't. We totally have the option to say, hey, you don't owe me anything for the work I did. Either you don't have a very good case after all, or you do have a good case, but given my current docket, it doesn't make sense for me to work on it. There's someone else that could give you more time and attention, and they would be a better lawyer for you. There's nothing wrong with saying that. In fact, it's the best thing to do if that's true. And so, again, once we gather information, then that's the second decision point. Do I really want to do this case or not? And Mallory, you've had a recent experience on that.
I have. I mean, it's an active case and an active client, so I don't want to say too much about it. But, one of the things that made me make the decision that we couldn't have the case was a really in-depth interview with the client. I knew that I needed that in order to take the next step. And so I set up a really in-depth conversation with the client where it had all the questions that I needed answers to. And ultimately the answers made it so that it's a case that doesn't work for us to do. It's not a case, and it's not a case that someone else might want, but for us to do it, it was going to be such an uphill battle. And the injuries, fortunately for the individual involved, healed fairly quickly and fairly well.
Yeah.
And so the amount of time, effort, money we were going to have to put into it, given the injuries and then the issues with liability on the case.
And the location.
And the location.
It was a case that was not in an easy place for us to get to. It was, far away in a place that doesn't have any good way to get there. And then the damages weren't what we thought they were going to be when we first started the case. And then the liability facts were a lot worse than we thought they were going to be. And so that's one where we need to say, you have a claim and they will pay you some money on that claim, more likely than not, if you pursue it. But we're not the right lawyers for you. In fact, frankly, our travel costs and travel time make the case make no sense alone. Given now, if the damages were what we thought they were, it would have been possibly a different calculus.
Yeah, and it is a hard decision to make, especially after you meet the client. I mean, in that case, the client was a very sweet person and very deserving of help. It makes it a challenging thing because you have to get to know them in order to decide whether you can have the case or not.
It's really tough. And I've actually, I do my very best to not meet the client until we at least get past the triage stage. Because once I meet a client, I will probably do the case, even if it's economically irrational. And that's one reason that I try not to. And it's the other reason that we've really tried to develop a firm culture of what I got it from Patrick Lencioni. Everyone that listens to me is going to got to buy all his books. I love Patrick Lencioni. He's a business author, talks about organizational health and how to have healthy businesses. And so one's called vulnerability-based trust, is that we trust each other enough to say things to each other that are true, and that it will be taken as we're trying to help the group, not I'm criticizing you. So one thing that I built up is that when I'm doing that you or Sonia or anyone else at the firm can tell me, why are you doing this? This is not what we said we're going to do. This is a bad idea. And then I will, at least 9 times out of 10 say, yeah, you got a point. Maybe we shouldn't do the case. Now, sometimes I'm pig-headed and I'll do it anyway. And, we all have to suffer the consequences. But more often than not, you all save me from my bad decisions now that I've empowered you to speak the truth to me without you worrying about, am I going to get mad at you or is it going to,
Yeah. Yeah. And we've had those conversations, about cases where, and it's hard when you meet the client because almost all of these people are very deserving of our help. I mean, they've been through something bad and they need help. And so you feel for them. Doing the right thing by them is getting them to someone that's a different lawyer that can put either more focus on it or different resources or different expertise onto their case to help them in the best way that they can.
And for years, I did try to help everyone, and I didn't say no. And as a result, I was always frazzled. As a result, I did not give my clients, especially on the really good cases, the attention that those cases deserved because I was too busy trying to work on too many at once. I was always behind, always having to get more time on things, get an extension on things. Would always have myself financially stressed because I was trying to work up so many cases at once and hiring so many experts at once. And then, of course, having way too many cases where we're settling and taking almost no fee because we got to get the client some money. And it just wasn't a very good case to begin with. And so, one, I found that doesn't really serve anybody, not just being selfish, but it doesn't really serve my clients. But two, I found even though someone's really nice and they want to appreciate you, they measure their recovery against their loss, not against the difficulties in the case or what the case would be, the quote unquote case would be worth. So if someone has had a death, for example, they've lost their spouse, that they lost their child, and it's a really tough liability case, and $500,000 or $750,000 is a really good recovery on that case, they're still going to not be happy and be pissed when they settle that case for under $1 million and it's a death. They're not going to like it. They're not going to be happy with you when you tell them all the reasons that the case has problems. And so you think that you're helping, you feel bad, and then they end up not happy with you. And even referring lawyers who are more sophisticated, at the end of the day, they remember, well, I gave this death case to this lawyer and he got $500,000. I gave this death case to this other lawyer and he got $10 million. And they forget that one was a really, really good case and one wasn't. So you almost get like negative points for taking the tough case and doing something with it.
Each year, the law firm of Cowen Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and company vehicle cases. If you have a case involving death or catastrophic injuries and would like to partner with our firm, please contact us. We have experience finding potential defendants that other firms miss, and we've added millions of dollars to cases by finding these sources of recovery. If you have a catastrophic injury or death case where the policy limits appear to be insufficient, give us a call. If we can find another defendant, we can partner on the case. And if we can't, then we won't ask for any of the fees. You can reach Delisi Friday by calling 210-941-1301 or send an email to podcast@triallawyernation.com. She will coordinate a time for Michael Cowen to speak with you in person or by phone to discuss the case in detail. And now, back to the show.
So we gathered all the information. We did sort of a second look at the case to say, do we really, really want this now that we have some more information? And let's say we decide, okay, we're ready to move forward. We've got the information. We do think this is a case that we want to work on. What's next?
Then it's a brainstorming exercise. We're trying to find everything because we don't know yet. We don't know. We don't have all the evidence. So and what we want to do is we want to start exploring what our theory is going to be, and then what do we need to find out in this case to win it, or to find out that, oh boy, we do have a real problem we didn't think of. And so, we want to identify and then analyze all potential, what I call immediate causes. And the immediate causes, what, in the moments before the incident, what was immediately what caused the crash. So we're not talking about the lack of training or the lack of safety protocols, but let's say it's a rear-end collision. So what are some immediate causes of a rear-end collision? Well, I guess technically any time a rear-end collision, you have the true immediate cause is that the driver who hit from behind did not apply their brakes in time to avoid the collision. But we want to go a little further back than that. So were they not paying attention? and that's why they didn't hit their brakes in time. Were they intoxicated? Did they have vision problems? Were they following too closely? Or was it a situation where our client slammed on their brakes for no real reason? Our client crashed into somebody in front of them, which didn't give them time to react. Although, if we're really looking at it, if you have a proper following distance, that shouldn't matter. But it's still something we have to look at. Was there a bee in the vehicle that stung them? Did they have a sudden medical emergency? I mean, we want to just be creative. I mean, and come up with. Don't be constrained by what you know so far from the police report or something. So we want to identify as many of these things as we can come up with. And again, at first, be non-judgmental. Even though they seem silly, even though they seem out there, you never know. And so let's go identify as many of these as we can. Now, once we identify them, then we say, okay, now let's look at the information we have available. Which of these can we say are very, very unlikely to have been a cause? And which of these are the ones we need to look at more carefully? So, let's say the sun was in my eyes or a bee was in the car. Well, if they didn't tell anybody at the scene that happened, they didn't tell the police officer, it probably wasn't that. So let's put that as a very unlikely event. Although there was a while, I think it stopped, where like one defense lawyer in South Texas, there were like 7 or 8 cases in a row where the defendant claimed there was a bee in the car.
Oh my God.
It was real clear what was going on. Like all your clients happen to have bees in their car, because that's a defense.
I have never, living in South Texas, I've never had a bee in my car. I don't think that's ever happened to me.
I don't know anyone it's ever happened to, except for this one lawyer's clients who kept claiming for the first time after getting sued they had a bee in their car. But I'm just throwing things out there. But that more likely than not, if certain things happen, it would have been told to the police officer. So we're saying, these things are less likely. We don't need to really focus on them. Just, there's an outside chance it could be. And so then we break them up into what I call winners or losers. And so winners are immediate causes that, if proven, we win. And of course, losers are ones that, if proven, we lose. Losers are things that are either our client's fault or anyone's fault but the defendant.
So what would be an example of like a loser?
Okay, a loser, let's say a defendant had an undiagnosed medical condition and suddenly had a stroke or a brain aneurysm, and therefore, through no fault of their own, with no warning, passed out and crashed. Or the vehicle in front purposely pulled in front and slammed on the brakes, pulled in front right in front of them and slammed on the brakes to purposely cause a wreck. Those would be loser immediate causes.
And so I guess winners would be something that would show some kind of negligence.
Yeah, like not following too closely, distracted by being on the cell phone, not getting enough sleep and falling asleep and then crashing into somebody, being drunk or on drugs, not wearing your glasses, brake failure. Well, brake failure could go either way. So on an 18-wheeler where they have to maintain the vehicle, brake failure is probably good. Brake failure, it probably isn't sudden, but, on a regular vehicle, if the defense can credibly claim brake failure, then you need to go get the brakes analyzed. And is this something that was building up that they would have had a warning, or is this a sudden unanticipated failure? And you need to think about these things at the outset, because it's going to affect your plan. And in fact, I'm getting ready. A friend of mine's bringing me in to try a case, hopefully next year when we're hopefully trying cases again, where that's one of the defenses was brake failure. He never claimed it before, but then he got a recall letter saying there was a recall on some brake component in the vehicle, and suddenly he says, "Well, it was a brake failure." Now, before I got brought in, the lawyer was pretty bright. He sued the auto manufacturer that did the recall and let them get a summary judgment. And so now the judges found that it wasn't the recall because there was no evidence.
Good.
But yeah, So right now we're just identifying them and analyzing them to see which are the potential winners and which are the losers, and then what can we just exclude as being very, very unlikely.
So what is the purpose of putting them sort of in these camps of winners and losers? Why are we doing this?
Well, because the winners, we're going to look at those in the next step. And I think that actually goes to our next step, which is the root cause analysis. So for the winners, if it's a case about like a trucking case or any other case where you have a corporate defendant or an employer, we want to do what's called a root cause analysis to try to figure out, was this something that just the individual who caused the wreck or caused the incident did wrong? Or is this part of what they call systems failure? Like, is this a bad policy? Is this bad training? Is this bad practices by hiring bad drivers? Is there can we make this case something bigger? So for the winners, we want to look about how can we make this something bigger? For the losers, we're looking at, is there any way we can either disprove them or neutralize them, where we can deal with them and still win the case. And so that's why I break them up from winners to losers, because we want to prove our winners and then make our winners bigger, and then we want to disprove our losers or find a way to, if the law in our state will let us win even though the loser cause is proven, can we still win?
That's step 3. We've identified our immediate causes, which are the things that happen right there at the crash, like just seconds before the crash, what was happening. And so then after we've categorized them into winners and losers, and we're going to try to make the winners, the sole focus of our case. We're going to try to minimize our losers. How are we going to get there?
Well, then that's the next step, the root cause analysis. So let's start with the winners. Because that's more fun to talk about. So we do what's called a root cause analysis. This actually was come up with a Mr. Toyota, who's the founder of the company that eventually became Toyota Motor Company. And back then, I think it was some kind of weaving or cloth baking, but he had a factory, and something would go wrong in the factory and they'd fix it. Then something else would go wrong in the factory and they'd fix it. But they'd just be dealing with the problems as they popped up. And he came up with the idea of, why don't we figure out why these problems are happening in the first place? And then if we fix that, the reason that the problems are happening, then we won't have as many problems pop up and we can make the place better. And so he came up with a technique called the 5 whys. And it's basically, you keep asking why until you figure out, what is the ultimate, what they call root cause of something happening. And this is really good because if you look at all the safety literature, it all talks about it's important to get the root cause. It's important that way you can fix your system and prevent other crashes from happening. If you look at the National Safety Council's, Preventive Accident Prevention Manual, or the also the one from the USDOT Preventable Accident Manual, it will talk about, it's important to go figure out why crashes happen, and then you fix your systems, you fix your training, you do what it takes to prevent the next one from happening. So not only is it a good way to analyze our cases, but it's something that also will be backed up when our experts eventually testify, because it's backed up by the literature. So I'll just give an example.
Yeah, I was going to ask, so do you literally just ask why?
Yeah, so here's this, let's say a rear end collision. And to me, a rear end collision, a rear end collision on one thing is an easy case against the driver, because most people think that if you rear end the vehicle in front of you, you're at fault. There can be some exceptions, but most of the time you're going to win a rear ender. Even if you screw it up, you're going to get something on a rear ender. But then you say, well, how do you make it about the company when it's a rear ender? That's more challenging to me. It's weird, but like the harder liability cases tend to be easier to make about the company, because since they are weirder things, that no one would know them unless they were trained on them. Whereas we all know you're not supposed to hit the car in front of you. So we got to put a little more thought into those. So let's take the one for, why did the tractor trailer rear end a car? Well, because the truck driver did not apply his brakes in time. Okay, that makes sense. Hard to argue with that. Okay, so why didn't the truck driver apply his brakes on time? Well, he did not have enough time to apply his brakes because he was following too closely. Why was the truck driver following too closely? Well, because he did not know how to determine the proper following distance. Why didn't the truck driver know how to determine the proper following distance? Because the motor carrier put him on the road without making sure he knew the rules for following distance. Why didn't the motor carrier make sure the driver knew how to determine the proper following distance? Because it chose not to spend the time and money needed to train the driver. So that is one theory. Now, it's really important here at the beginning, this is a theory. And so, when I have time, when it's like a big case and I have time, I have like multiple root cause analysis that I've done. So, like, okay, so if it's the driver's following too closely, this is what it's going to be. If it's the driver's distracted, this is what it's going to be. If it's the driver's fatigued, this is what it's going to be. Because while I have my working hypothesis, when I'm, later on when we talk about doing the discovery plan, I need to be exploring all of these angles to see which one is going to be best. So that's what we're doing on our winners. And then our losers, I need to look at, could I disprove this? Is there a way I could disprove this? And so what do I need to do to look at whether I can disprove this or not? And then if I can't disprove it, then can this be true and can I still win? So I'll give you, we had an example where our client was a passenger in a car. The 18-wheeler was parked partially on the shoulder of the road, partially blocking traffic. The driver of the car was not paying attention, was playing with their cell phone, did not slow down, and just slammed into the part of the trailer that was sticking out. So one of our loser causes was the driver of our vehicle was not paying attention and slammed into the back of a tractor trailer. There was nothing we can do to eliminate that.
Right. We could not disprove that in that case. That's what happened.
It was an absolute truth. So what did we do?
So in that case, we made an effort to say, yes, that's true, but here are the reasons that we should still win, right? So here are the reasons that the 18-wheeler had a driver and the company had more of an opportunity to have prevented this than our driver. They were more at fault.
Yeah, yes, and since we had a passenger and we're in Texas, all we had to do is prove any fault on the 18-wheeler driver to get some liability. Now, to get our joint and several liability rule in Texas, we would have to put 51% on the trucking company and driver. But yeah, it just had to be, yes, our driver was not paying attention, and yes, our driver was negligent. We agree with that. We don't even have to talk about it anymore. That's true. That's why you don't park your vehicle blocking part of the lane of traffic. Because when you block your vehicle part of the lane of traffic, not all drivers are attentive, and some will hit them. And you know what? Maybe if those drivers get injured or killed, they deserve it, but their passengers don't. Their passenger didn't have anything to do with that, and that's why, because we care about teenage girls that are passengers in vehicles, and everyone else was a passenger in a vehicle. We don't block partially block the lane of travel with a tractor trailer, and so we just had to embrace it. Like, yes, that's true. So what? Spit on that, as Rodney Jew would say.
Yeah.
And then sometimes it is the loser is so bad, you have to say, yikes, I made a mistake on this one. Either take what's on the table or go home and find another case to work on. Because there are cases where, we come back and it turns out the client was on drugs. And look, there are people that have taken those cases where the driver is on drugs and crashes with an 18-wheeler and still win. And, I admire them. But it's a much more difficult case. And there are just cases where, when we've done our investigation, we've gathered all the fault, and our client is clearly more at fault than anybody else. They're speeding, they're doing crazy things, and we just have to say, well, I'm sorry, and this is not the right case for us.
And I just want to remind the audience listening, we're on step 4 here, and we haven't filed a lawsuit generally yet. So I told you, we're not going to do that until the end of the podcast, but I just want to remind everybody, this is all happening at the outset, hopefully before you file the lawsuit. I know that's not a luxury that we always have. But
sometimes you have to file a lawsuit to get like a temporary restraining order to prevent evidence and stuff, to freeze evidence and stuff like that. But ideally, you have the time to do this stuff really early on, and it's stuff you can do before you file a lawsuit, because everything will go better if you do it that way.
So at this point in step 4, we've done our root cause analysis, and maybe we have a couple of different ideas about what could possibly be the root cause of the crash. Have we looked at the case again to see if we really, really want the case at this point?
Usually I'm not formally making a decision, but you always want to be continually asking yourself, and we do it with employees too. I mean, every quarter, we have a meeting of our management team, and we go through every employee, and we ask ourselves the question, knowing what I know now, would I enthusiastically hire this person if I had to do it all over again? Now, with employees, it's a little bit different, because we don't just fire everybody where the answer is no. Because if the answer is no, we say, okay, is this something we can work on fixing, or is this unsolvable? And then we either have a plan to try to fix it and then reevaluate it in 3 months, or we say, this is not salvageable. It's time for you to find a place where you'd fit in better. Not you, Mallory, but luckily that hasn't happened much lately. But I mean, it's something that's important in our business. It's also important with our cases, So yeah, I think we always have to be kind of asking ourselves, like, knowing what I know now, would I have taken this case? And the answer is no. Then the second question is, does it make sense to stick with it? Now, sometimes it does. Sometimes, let's say you've got $100,000 invested in a case and you can get money in them. I mean, there's like settlement opportunities. So it doesn't make sense to say, well, I wish I hadn't taken this case, so I'm going to give up now and lose all my money, when without a whole bunch more work, I can get it settled. But there are times when it says, well, it's early on in the case, and yeah, I've spent some money on it, but I'm going to spend a lot more time and money on this case, and I'll be fighting this to get it back. So yeah, we always want to be thinking that.
So after the root cause analysis, what's our step 5? What's our next process for analyzing a case?
Yeah, it's drafting the jury instructions. And I've always heard this, and until I went and worked with a consultant named Rodney Jew, I honestly thought it was silly. Because Texas, we use what's called a broad form jury instruction. So it's just, negligence is a person's negligent if they fail to use ordinary care. They don't do what a person with ordinary care would do, or doing something a person with ordinary care wouldn't do. And so it's like, well, I know that definition. Why do I need to think about that? But it actually, when you draft the jury charge, and then who you're going to put on the jury charge and what your theories are going to be. In some other states, like North Carolina, has wonderful stuff. The driver has a duty to look and see what's there to be seen. They have real specific things on the duties. So that's really helpful. But even if it's not, just look at what do I need to prove? And then especially in Texas, we can get gross negligence and possibly get punitives, or at least put in a lot more fun evidence. And, then we have to see, well, what do we need to do to prove punitive damages, to prove gross negligence? We need to have something that is objectively extremely risky and dangerous, subjectively that the defendant knew about it, and that conscious indifference, that even though they knew about this objectively super dangerous thing, they did it anyway. Knowing what the standard is lets you design the rest of the case to find the evidence to prove it. And when we haven't done that, and then we get to the summary judgment or directed verdict stage, man, I wish I would have asked that question.
Right. And a lot of it is thinking about documents you need to get to prove these elements, or testimony you need to get to prove the elements. And if you haven't thought about it early, then your deposition will have come and gone, and you wish, I wish I would have just pushed for that one extra question, and I would have had this all wrapped in a nice little bow to give to the judge for the summary judgment hearing.
Absolutely. Starting with a jury instruction, it really makes a lot of sense. And especially when you're doing a case out of your jurisdiction. Because, they're not all the same. And sometimes you have to do a little bit of legal research too. So maybe the jury instruction is going to be like a broad form jury instruction, but you're doing a negligent training case or a negligent entrustment case. Well, do a little bit of research. How many recs or tickets on a negligent entrustment in your jurisdiction do you need to sustain a verdict or get past summary judgment? Look at the case law. And so, it takes a little bit of figure out what is the bar we have to meet to make this case.
And I want to add in this section, it's not only about drafting your jury instructions for the liability section of your case. It's also about thinking about your jury instructions for the damages part of your case. What are the damages you're going to ultimately need to prove, and who's going to sponsor those? I mean, who's going to say this injury caused mental anguish or pain or whatever it is in your jurisdiction that you have to prove? What do you have to prove to keep those damages on appeal?
Absolutely, because if you don't develop them, you're not going to get them.
Right. So it's thinking about the entire jury instructions. I just want to make sure people don't think, well, I've thought about liability, and damages is just as important of a part of the case as liability.
Absolutely. I mean, finding a negligence in a tiny verdict the client's not going to be real happy with you.
Right. And doing some case law research to see, like in Texas, there's not a lot of instruction for the jury about the damages. They just have to fill in blanks for things like physical pain or physical impairment. But there's actually some case law. If you read it, what is it that you have to show to the jury to give them the basis for a physical impairment award? And so knowing what that is helps you figure out how to develop testimony or evidence about that.
And how to prep your client and when they give their deposition. Like for mental anguish, we need to show a substantial disruption in the daily routine more than mere annoyance, fixation, worry. And so you've got to figure out what those elements are and spend time with your client. You don't tell them to lie, but spend time with your client. Have you had, has this ever kept you up at night? Have you ever had headaches? Have you, and when you ask the question, like, yeah, I think I have, and then prepare them. Well, that's going to be important when they ask you, and do a little practicing so that way, they don't kill part of their case on their deposition if it's true that they've suffered those damages. Because sometimes you just don't think about it until you take some time to sit and reflect. And so if you don't ask the right questions and prep, and so, like I said, but you got to go back into knowing what is the law, what do we have to prove?
Right. And your clients don't know what it is that they need to testify about. I mean, they don't know the law. They rely on you for that. And, if someone has a very painful injury, they're naturally inclined to want to talk about the pain associated with the injury. But actually, you have a lot of other elements of damages that you can, that they should be compensated for, that aren't just pain. And so getting them to think about things other than pain that have been affected it's just something you need to address.
Absolutely.
Thank you to everyone who attended Cowen's Big Rig Bootcamp in August. We had an excellent virtual turnout this year and are already thinking of how we can continue to raise that bar for next year. If you'd like to attend virtually in 2021, be sure to mark May 20th, 2021 on your calendar now and save the date. To stay updated with details as they become available, visit bigrigbootcamp.com and sign up for our mailing list. And now, back to the show.
How does drafting the jury instructions sort of help you move your case forward? And how do you use the stuff that we've already done in this stage?
Well, actually, that's going to be step 7. So we're kind of skipping ahead. So we are going to take the jury instructions. We're going to get an idea of what we need to prove. But actually, the next thing we're going to do is we're going to find what we call rules and anchors. And so hopefully most people have read The Rules of the Road by Rick Friedman and Patrick Malone. But you don't want to just say the defendant was negligent, the defendant could have been more careful. One of the things you always ask is, says who? Okay, so you say, well, the defendant should have had a bigger following distance, let's say a 4-second following distance or a 5-second following distance, depending on the speed and the length of the tractor and everything else. Well, says who? I mean, says my expert? Well, who cares what my expert says? I'm paying them money. Says me? Says a lawyer? Someone's going to believe a lawyer? Come on. So says who? And so what we want to look for are authoritative sources for the rules. So where do the rules come from? And that's one of the reasons I love trucking so much, because there's so many great rules out there. So, for what the following distance is, every state has a commercial driver's license manual that's based on a model commercial driver's license manual created by the U.S. Department of Transportation. And it sets out the rules for setting out what the following distance is. So if following distance is going to be an issue, we can start there. But then you can look at other things. You can look at truck driver driving course manuals and textbooks. You can look at defensive driving training. You can look at other trucking companies' trucking manuals. And what you want to do is you want to be able to layer all these rules. So it's nice if you have, we have one source that says this is what the rule is. It's even better if we have 10 sources that say this is what the rule is, because then at that point, what are the defendant's choices? They can agree that that's the rule, in which it's going to be basically agreeing they broke it. Or they can look really stupid and dangerous and silly by saying, we disagree with all these sources and we have our own rule. Like you had one yesterday, I think, where the defendant driver said, well, there's a rule somewhere saying you can actually go 10 miles an hour over the speed limit, and that's okay.
Yeah, he said there's a rule that says there's a real speed limit that's not the posted speed limit, and it's 10 miles per hour over the posted speed limit. Okay,
which is wonderful. Which is a wonderful thing for a defendant to be saying in our case when he was going 10 miles an hour over the posted speed limit or more. I don't remember the exact speeds, but it was not good for him. Yeah, so we want to find as many, authoritative rules and anchors as we can, and it can go both ways, not just on liability, but on damages. And you have a traumatic brain injury case. What are the rules, or what are the sources for what are the symptoms of a traumatic brain injury? What do you need to have or not have? So, on a traumatic brain injury, they'll say, well, the defense will say, well, the Glasgow outcome score was 15, which is like a little assessment they do in the ER or the ambulance. Well, the definition of mild traumatic brain injury set out by in the literature says you can have a 15 and still have a mild traumatic brain injury. They'll say, well, the CAT scan was normal. Well, the definition says you can have a normal CAT scan and have a traumatic brain injury. And so we need to know what these things are so we know how to assess it. So we just need to we're gathering our ammunition for the case.
The finding rules works in almost every context that you're going to find negligence. So it doesn't just work in trucking cases. You can find it in workplace injury cases, with rules for OSHA. You can find it in premises cases, depending on what the situation is. So it's, I don't want you to feel like we're limiting this discussion, the audience, to feel like we're limiting the discussion to trucking cases. These are just examples. But you can find rules for almost anything where someone was negligent because, people generally know what an ordinarily prudent person would do. So
absolutely. We've done, you and I tried a construction site case where a trench collapsed and killed somebody. And, so there was the OSHA regulations. Sonia and I worked on a dram shop case, and there it was on different associations training materials on not over serving people and what the standards are for counting drinks and how many drinks you're giving someone and what are the signs and symptoms of intoxication. Sometimes product liability, you have to go a lot more global and just say, you look at the design guard warrant hierarchy. If you have a known danger, you try to design it out. If you can't design it out, then you guard against it. If you can't guard against it, then you warn. And if you can design it out, you don't worry about guarding warning, you just get rid of the danger. If you can't design it out, then you go to guarding. If you can't, so a warning doesn't excuse a bad design. That's like big high level stuff, but you can at least get that. But you need to know what they are. You need to know what the rules are. Just like you need to know what the law is, you need to know what the rules are before you even start on your case.
So we're at step 6 in this process. Now, rules, the step 6 is called find rules and anchors. And for people who might not know, what does it mean, an anchor?
Okay, an anchor is going to be what we're anchoring our rules to. So the anchor is going to be the authoritative source or publication for the rule. An example of an anchor in a trucking case is a commercial driver's license manual or another trucking company's manual, a defensive driving book, a trucking company textbook. In a premises case, it might be an ANSI, American National Standards Institute standard. It might be another store's rules. It might be an OSHA rule. But you need to find out what they are. And then you need to, and a lot of people would say to hire an expert to do this. And I really think that doing the research on your own before hiring an expert, there's so much available online. Now, the expert will find things you don't know, but so many experts have the habit of just saying, well, based on my experience, training, and education, this is what the rule is. And a lot of experts don't like using anchors because it ties them down to having to take a firm position on every case once they admit to something being an anchor. And so, you can kind of get fool's gold where the expert says it, I'm going to prove it. Well, juries don't give a crap what your expert says. They really don't. I mean, no matter how charming you think they are, and they don't give a crap what the defense expert says because they're getting paid money to be there. And no one gives anyone any credibility. No one believes experts unless they agree with them already. Unless the expert's telling the jury what they already believe, it goes in one ear and out the other because they're getting paid money. And that's why you have to think of, I'm hiring the expert so that I can have someone sponsor these rules and anchors that I'm going to use to prove my case. Mm-hmm. And if your expert won't do that, remember, you're paying. Find another expert. Yep. I would rather have someone who's less of a dynamic testifier, who's going to use rules and anchors that are going to let the jury come to their own conclusion, than to try to get some, golden boy or golden girl to go and charm the jury and just make them eat out of their hands and win, because I just don't think that works.
Yeah. I think if your strategy is to charm the jury, you're not starting off on a good foot. Yeah, for anyone.
I'm not that charming.
Not you personally, but any attorney or any, if that's the plan, I don't think that's a good plan.
Yeah.
So we've found rules and anchors, we've drafted jury instructions, we've analyzed our causes of the crash. What's next?
I have Formulate discovery form. This is probably when we draft our complaint or we draft our petition, and we plead what we're going to need to plead to get discovery into what we want to find out, because discovery is based on what's relevant or reasonably likely calculated to lead to discovery of admissible evidence, and that's going to be based on what's in the pleadings. So if we think that our root cause is going to be negligent training, we need to, at least on information and belief, train that they had an inadequate training system. We found out the driver has a lot of prior crashes, or that the company has had a lot of prior citations, and we want to have some kind of negligent hiring or negligent, this kind of negligent safety systems and safety culture in the company. We need to plead what they've had at least these other problems, and as a result, upon information and belief, they are negligent in their training or negligent in their safety policies. Because if we don't plead that, we might not get discovery into it.
Yeah.
And then we got to formulate a discovery plan. So basically, this is another trap that I used to fall into, and I see a lot of people fall into. Can someone get me a set of interrogatories on this kind of case? Or can someone get me their deposition outline on this kind of case? And, the problem with that is then you are litigating somebody else's case. You're not litigating your case. And you're going to get the information you need to prove or disprove someone else's case and not what you need for your case. And so really, what you need to do is go back and look at, okay, these are my theories. This is what I want to prove. This is what I want to disprove. What do I need to get? What do I need to find out? What questions do I need to ask? And just write out kind of a list and an outline, and then draft, okay, what interrogatories should I send for this? What requests for documents should I send? Who do I want to depose and what I want to ask them? And just kind of outline it out. And then that's how you draft your discovery. Then get the form. Because if you get the form, then you can check out, oh yeah, I guess that's a good thing to ask. I forgot to ask about X or Y, and then you can add that into what you already have. But if you start off with someone's form, you're going to lose that creative process, and you're not going to get the stuff you really need for your case.
Right. Yeah, forms have a place, but it's after you formulated your own plan. So the forms have a place to go back and check your work, but they shouldn't be used at the expense of doing your own work.
Absolutely. And this is, I've done a 180 on this. I was more on let's get these cases moving, and I had created forms and we're just sending them out in every case. And now it's like, okay, we need to take a step back and do your own work first, and then generate the form and compare.
Yeah, and just as a practice point, Michael taught me this, that sometimes dictating can be easier than writing, and sometimes writing can be easier than dictating. But I find that when I'm thinking about deposition outlines and forming a discovery plan, that dictating is so much easier because I can be looking at what I have and just dictating all my thoughts about it, right? What are the kind of the questions that I'm thinking of as I'm going through what initial information I have? And then it's kind of already in a Word document for me, and I can go and arrange it and add stuff to it. But there's a few really good apps for that are fairly inexpensive for the products that you get. So just a little practice point for people.
Yeah, Rev.com or Rev, R-E-V, is a good app. SpeakWrite, SPEAKWRITE, is an app I use also. Both of those, you get real people. It's not just a computer. Honestly, the dictation part of my iPhone isn't that bad. It does a decent job, but given the importance of what we do and my crappiness as a proofreader, I like to get a human being to listen to what I said and to type it rather than relying purely on the computer.
Enjoying the episode? Do you wish you had Trial Lawyer Nation on the go? Well, wish no more. The Trial Lawyer Nation app is available now exclusively on iOS devices. Access our entire podcast library, create a favorites list, search for old and new episodes, and much more. It truly is Trial Lawyer Nation at your fingertips. Download this free app now and enjoy the top legal podcast for plaintiff attorneys wherever you go.
So just some ideas for getting, because it does feel a little overwhelming to say you need to just start from scratch and write everything anew. But, you need to remember, one, this is your case and you know it. So you're going to know what you need. But two, start from the very beginning and just start talking into your phone and say, I want the police report. I want any statement that any witness has given about this, right? I want to see what the training is that this person had that did this crazy thing. I want to see, if I think it's a maintenance issue, I want to see all the maintenance records for this vehicle to see what kind of work was done on it, right? It's going to come naturally as you think about it, but you have to set aside time to think about it. It's not going to come in 30 seconds.
And the younger lawyers or less experienced lawyers or lawyers going to a new area, don't be intimidated by the fact you don't know everything yet and you don't know everything to ask, because you're going to look at the form afterwards. But what you're wanting to do is come up with as much as your own original thought, because you want to come up with the things that might not be on the form. And you're still going to go look at the form afterwards, and you can stick as many things in there as you want after. Most jurisdictions don't have really big limitations on on deposition topics or on requests for production. So it's okay. I mean, you're gonna get it. And then if worst comes to worst, ask around, brainstorming. I mean, we put something out on you did on the Academy of Truck Accident Attorneys listserv. We had an issue. Other people had the issue. You all set up a Zoom call and you all just sat there and talked about the issue. And, we've done the same thing. Got some friends together that do similar types of cases, and we just get on a phone call or get on a Zoom call and we just brainstorm it together. And it's fun. And lots of people will do that with you. So take advantage of that too.
Yeah. And they say that nobody is as smart as everybody. So
that's right.
You don't have to have all the answers either.
Yeah. But please do try to do it yourself first. You're going to learn more, and you're going to get things that aren't on the form when you do that. And you're also going to be able to eliminate things from the form, saying, well, this was on someone else's form, but I had a set at one time that I was sending out in every case of almost 400 requests for production in trucking cases. And at least 350 of them were irrelevant in 90% of the cases. And I had to gain the confidence to say, hey, I'm going to go and do what's really important for my cases. And just because someone else asked this in another case where maybe they needed it, doesn't mean I'm going to ask for it mine.
And so we're about at the time where we're going to be filing the case, or it's already filed maybe, and we're starting the discovery plan. I think it's important to know that all of these steps, you go back and you reevaluate them throughout the case. So it's important to write down what you do so you're not redoing work constantly. So if you're going to go back to step 4 and look at your root cause analysis, you don't want it to just all be up in your head. You want to be able to go back to it later and say, you know what, I've actually eliminated this one now. So let's just not focus on this anymore. Yeah. We found out it wasn't a maintenance issue. So throw that one away. We don't need to worry about that one anymore. Let's focus on these other 2 root causes that we possibly identified. So make sure that you're keeping a good little memo for yourself of what you've done so far, so you're not redoing the work over and over again, because it's stuff you're going to want to refer back to.
Yeah, I recently looked back at a root cause analysis I did about a year and a half ago on a case, and it's like on some stuff I felt good. Like I thought that this was a possible cause, and we've asked the right stuff, and it turned out to be really good. Some of the other areas I was just, nope, that didn't work out, and that's okay. That's why I had multiple potential causes, because there's a danger. You and I we're getting ready to try a case. Unfortunately, Judge bumped it, but we went and spent a whole week with Rodney Jew and developed a theory and a root cause and all these exhibits. And, moving into step 8, which is continually reevaluating the cases, that was based on our working hypothesis before we took any depositions. That was based on the initial responses to written discovery. As we got more documents, as we took the depositions, we found that our initial theory wasn't as good, and we evolved and got a better theory. Because we haven't tried the case yet, I'm not going to go into the details on that one, because we have learned defense counsel does listen to these. But our case actually now is, I think, better than the one that we had worked up then. But it's also, if we had tried to stick with our initial theory, we were going to present a case that would fall flat because it wouldn't ring true. We'd be trying to stretch the evidence into something it really isn't.
And as you're continually reevaluating the case, I want to encourage people to not be afraid to send a discovery request for what you really want. People, I think, are too ready to send sort of a broad, generic one because they want to get everything that they might have. But when you get a document that references another document, send a request that says, give me this thing identified at Bates page 88 in your discovery, right? There's no harm in sending and asking for what you really want so that you can get what you really want.
Yeah, Sonia, our partner, is like, we have a case where she's like, we got some emails and they didn't give the attachment. So like, I want the attachment to the email that's Bates numbered, 8523. I want the attachment to this, because we just asked for all the attachments and most of them are irrelevant. We're not going to get them. So, but I want this particular attachment. I want this particular document. And so, yeah, I think, when they produce documents and ask for discovery, read the documents, and then say, what else do I need? And then say, do these documents make my working hypothesis more or less likely to be true. So sometimes it's like, okay, we said it was a lack of training case, and we find out, boy, they had really good training. Look at this video. Look at they had someone drive with the person. Well, okay, no, it wasn't lack of training. They did more than the average person. So then why did it happen? So why did they have a driver on the road that ignored what he was trained to do? And
Yeah.
it's another, is it a monitoring? Is it a hiring? What's the problem here? We have to evaluate it. I also, and I don't always, I should always do this. And, one of my weaknesses is I'm really good at coming up with ideas. I'm not as good at following up on them, which is why I work with great people that are much better at follow up than I am. But after every depot, when I take depots, I make notes while I'm taking the depot, and I put little stars on things that I want to follow up on. And then afterwards, write a memo. For me, it's better to dictate because I have my notes in front of me. Request this document, request that document, depose this person, have either investigator or I needs to speak to this potential witness. And if you do that right after the depot, and then go back and look at your, the next day, okay, let's look again. Does my root cause analysis still make sense? Which one of these is more likely to be our case? Have I ruled out any immediate causes? Have I proven any immediate causes? And if you do that after every deposition, after every time you get documents or get discovery answers, then you can refine and send follow-up and just find the theory that works best for your case.
Yeah. And I know Sonia, she sometimes she'll send 10 different sets of requests for production in a case because she's slowly whittling away to get the thing that she really needs. That's also one of the dangers with forms is they're very broad. And so you're going to get a lot of objections. And so you may or may not know if you actually have what you really need. If you're sending something that says all the email attachments that ever were, right, that's going to get an objection and you're not entitled to those probably. So by doing very specific tailored discovery requests, one, you'll get what you really want, but two, you don't have to dig through a bunch of crap to find the good stuff either.
Yeah, when you go to a judge and say, in deposition, this person said that this document exists and this is what the document's about, and that they read the document, so I want a copy of it. It's a lot easier than, Judge, they say they've given us everything, but we think there's more. How do we prove they've given us more? Yeah.
Right. So that's the step 8, continually reevaluate. But you're not just reevaluating your discovery plan. You're looking at the root causes, your jury instructions. Maybe as you go through, you find out you have your case is a little different than you thought. Maybe it's more of an agency case. You need to look into that. Or there's, some issues with broker liability that you need to look into, or, other possible defendants that you need to.
Do you need to add a party? Do you need to drop a party? And, so I think that there's another thing we do at our firm on the reevaluation is, every case has what's called a star rating at the firm because we want to try to focus a lot of our efforts on our very best cases. And we also want to identify, the dogs that need to be either let go or settled or, cases that don't. So, monthly we reevaluate, do we need to change the star rating? So it's based on what is our probability of winning? It's an estimate. What is the probable settlement value of the case? And, so has something happened that's materially changed whether this is a good case or not? So is this a case that, hey, this case just got a lot better? So let's put even more resources into it. Or is this something like, oh boy, we got some real problems. We need to reevaluate how we're handling this case. Maybe this one we need to get settled, or, I hate doing it when you're really, really working on it, but maybe this one we need to get out of because, let's say the client absolutely lied to us and it turned out that they had a wreck the week before and it already had all the same symptoms at the time of this wreck, we got a problem here. The client won't take the money. We can't win this case. So I think just continually reevaluating it. And I'm not saying that we dump a bunch of cases when we've been working on for a long time, because we don't. But we do change our mind on, we think a case is worth a bunch of money, and then we find out that our client was lying to us and there was a bunch of prior medical, that value goes down. And, more often we find we've dug and we found a really good theory against the defendant. The jury's going to be really, really mad at them and the value goes up. But we have to constantly be looking at that because it's going to determine, do we need to do more work on it? Do we need to replete it? Do we need to kind of hire another expert? Not use a particular expert, just continually reevaluating on an ongoing basis, and not being stuck with what we did, the root cause analysis, the plan we had based on incomplete information, that when we get more information, we don't just blindly follow the plan we made when we didn't know everything.
Right. So the final step that you have is test the case. Step 9.
Yeah, because so far we've all done this kind of in our own mind, and so we've convinced ourselves this is a really good case. Well, can we convince someone who's not getting a percentage of the recovery that it's a very good case? And there's lots of ways to do it. And again, it's budget dependent. So if you have a smaller case, you might want to just talk to people about it. Talk to people around the office. My wife is brutally honest with me, so she'll tell me like that's a good case or that's not a good case. She even told me like the night before closing, you're going to lose this case, which is not particularly helpful. But she's got like a 98% correct rating. I mean, she almost never gets it wrong, which is really frustrating. We'll argue, and then the jury will agree with her. What I go to law school for. But I've learned to listen to her too. But and then for bigger cases, you can do focus groups. There's some online stuff you can do. There's in person. There's advantages and disadvantages to both. The in-person focus groups is a smaller sample size. And you also have a presenter bias. If you have the same person, if you're not really careful, you can overweight your case and not weight the defense case enough. The other is, we've had cases where, one really, really good lawyer will present one side, and then maybe a lawyer who's not as good at presenting will present the other side. And so that can cause issues, so depending on how rigorously you want to test it, you might want to have someone, do a neutral on both sides or put the stronger trial lawyer on the opposite side. So you're testing as you can, but you at least want to see that people kind of buy the test. Now also, there's the John Campbell's empirical jury, there's e-jury, there's some other these online things where, now you lose all the human touch. They're just seeing some video, they're reading some things, but then you get hundreds of people to look at it, so you have a better idea. Now, all these tests are not going to they're not 100% predictive. Because even within the test, you'll find that different people and then different groupings of people will have wildly different answers. But at least if you've got a shot, and what the big issues are, what they're coming up with. And again, you don't want to just take it and get depressed by it. You want to take it and figure out, okay. And sometimes you do. Sometimes like, okay, this case is one we need to get out of this one. We need to settle this case. We tested it. People hate it. I had a whole line of cases I was doing like 10 years ago. I was doing these particular product theory all over the country, and focus group after focus group after focus group said we weren't going to win these cases, and I eventually settled them all and moved to something else. But a lot of times, like we do a focus group, we find we have issues, and then we come up with a plan and we solve the problem, and then we do another focus group, and we're like, yeah, our plan worked. So. But, test it. It doesn't give you 100% prediction, but it gives you ideas, to see, are people buying this? What is the range of values that we can have? How much money can I ask for without being so shocking that I turn people off? It's just very helpful.
It also gives you a method to address, I can't get over it issues for jurors that don't matter to you. They're issues that don't legally matter, but matter to jurors that you just have to address and you have to figure out. So, I know it's always surprising what jurors will focus on, at least to me. It's, things that just don't matter at all in the case. But now you need to at least mention it in the case when you're presenting it to a jury so that that juror that thinks that matters has their answer and they're not wondering.
So basically that's our simple 9-step process for evaluating and working up a lawsuit. We do this on at different levels, on different cases. Obviously, on the biggest cases, I actually have all kinds of written root cause analysis on every possible root cause. On a smaller case, it's done a little bit more kind of notes and memos and stuff in my head without as much detail because, you got to give the case again, you're triaging your own time, how much time and effort. But the basic process, I think, is the same for almost every case.
I think that's right. But you do have to budget your time wisely. And our biggest cases, we spend days doing this process. And some of the cases that are big to the client, but smaller in value, you spend a few hours doing it. So you need to use your time wisely.
So I hope this was helpful. We could probably talk about this more, but I actually have to present a webinar in a minute. So I've got to go do some other talking.
We'll let you
Malorie,
go.
As always, I enjoyed talking to you. And I hope everyone joins us next time on Trial Lawyer Nation.
Thank you for joining us on Trial Lawyer Nation. I hope you enjoyed our show. If you'd like to receive updates insider information, and more from Trial Lawyer Nation, sign up for our mailing list at triallawyernation.com. You can also visit our episodes page on the website for show notes and direct links to any resources in this or any past episode. To help more attorneys find our podcast, please like, share, and subscribe to our podcast on any of our social media outlets. If you'd like access to exclusive, plaintiff lawyer-only content and live monthly discussions with me, send a request to join the Trial Lawyer Nation Insider Circle Facebook group. Thanks again for tuning in. I look forward to having you with us next time on Trial Lawyer Nation.
Each year, the law firm of Cowen, Rodriguez, Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and company vehicle cases. If you have a case involving death or catastrophic injuries and would like to partner with our firm, please contact us. We have experience finding potential defendants that other firms miss, and we've added millions of dollars to cases by finding these sources of recovery. If you have a catastrophic injury or death case where the policy limits appear to be insufficient, give us a call. If we can find another defendant, we can partner on the case. And if we can't, then we won't ask for any of the fees. You can reach Delisi Friday by calling 210-941-1301 or send an email to podcast@triallawyernation.com. She will coordinate a time for Michael Cowen to speak with you in person or by phone to discuss the case in detail. This podcast has been hosted by Michael Cowen and is not intended to, nor does it create the attorney-client privilege between our host, guest, or contributors and any listener for any reason. Content from the podcast is not to be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they can